This is the Ulliance Hipaa training for new staff. What you don't know can hurt you. The point of this slide is that you have to be aware of the Hipaa laws. You can't claim plausible deniability. It is important that you learn them. You are held accountable to them even if you didn't know. History of the laws. In 1995, the Health Insurance Portability and Accountability Act was put into place. This allowed people to take their insurance with them from job to job, and it also created rights for an individual to have access to their records, as well as confidentiality and privacy. The privacy rule came into effect in 2003, and then the security rule came into effect in 2005. We'll get into the specifics of the privacy rule and the security rule as we go through this training. The HITECH Act came into effect in 2010. That is the Health Information Technology for Economic and Clinical Health Act. The HITECH Act focuses mostly on the technology piece of Hipaa. The final ruling was in 2013, and then in 2014 they added the Clinical Laboratory Improvement Amendments, which in summation allows an individual to have access to their lab results. The U.S. Department of Health and Human Services issued Hipaa in 1996. It is enforced by the Office of Civil Rights. The deadline for compliance was September 23, 2013. So let me begin with some of the terms that you will see in Hipaa. These are the formal official terms. Covered entity. A covered entity is health plans, clearinghouses, and any healthcare provider who transmits health information in an electronic form or connections with these transactions. Ulliance is a covered entity. Covered entities are required to follow the Hipaa standards. Let's begin with the privacy rule. Privacy rule. The goal of the privacy rule is to assure that individuals' health information is protected while also balancing that with the flow of health information that is needed to provide high-quality care and protect the public's health and well-being. The privacy rule defines and limits the circumstances in which an individual's protected health information, otherwise known as PHI, may be used or disclosed by covered entities. The privacy rule defines and limits the circumstances in which an individual's protected health information may be used or disclosed by covered entities. A covered entity may use or disclose PHI as the rule permits or as the individual who is the subject of the information authorizes it in writing. PHI, in any format, is information that is created or received by a covered entity. So there's two pieces to PHI that are important to note. The obvious for most people is anything related to the record itself. So anything that's been created in the past, present, or future physical mental health condition of a patient, and you're allowed to disclose it for the provision of care or payment related to the patient. The second piece that is protected health information where a lot of people stumble are identifiers. A significant point to make is that employment records are not considered PHI. Therefore, an employer is not required to comply with Hipaa standards when communicating and transmitting employee information. This is relevant to Ulliance as an EAP because our contacts at our client companies may send us information that presents as PHI, but it's not for them. However, for us to respond back, it is considered PHI because we are a covered entity responding regarding that individual's records. So this is most important with formal referrals and why we need the release. So that back part where it said we need it in writing, that's why, is so that we can share back to the company. But they are not required to follow because they are not a covered entity. So going back to the identifiers, these are outlined specifically in the privacy rule. So these are not up for interpretation. A lot of people struggle with agreeing with these. It is important to know that these are listed specifically. So the name, including initials, geographic subdivision smaller than the state, any elements of a date except for the years, ages over 89. The logic behind that is that there's not that many people that are 90 and above, so usually you can narrow down who it may be, and that's what they're trying to avoid. Telephone or fax numbers. More identifiers that are considered PHI, email, social security number, the medical record, the health plan number, or the account number. Lots of times people make the mistake by thinking that they can just do the chart record and that is confidential. It is not. That is considered PHI. And you can look through the rest of the list: certificate, license number, VIN, device identifiers, biometrics, picture of the person. And then the last piece, which is important to note, is other unique identifying characteristics or code. An example of this would be a nurse that may describe a patient that she's worked with on her shift that's 500 pounds and it was very difficult that day. That would qualify. That's a unique identifying characteristic. It's something that's unusual that you could narrow down who at this hospital is 500 plus pounds. Oh, she must be talking about that person. So it really has that catch-all at the end, so you have to be very careful. Permissible use of PHI. You can use PHI for treatment, for payment, for healthcare operations, when written authorization has been obtained by the individual, when disclosure is permitted by regulation. So in Michigan, for example, we have the child protection law, which means you may be a mandated reporter to report to Department of Human Services suspected child abuse. You're allowed to disclose in that place. Friends, family involved in the care of payment. So the specific part of this that they say is if the patient does not object, or it can be inferred from the circumstances that the patient would not object. How this would apply to Ulliance, for example, is we may have a formal referral where somebody is engaged in counseling to try to work out some issues regarding their job, and they may go to an inpatient facility and we're unable to get in contact with them. They would give us a secondary phone number or an emergency contact. We can reasonably infer that that person would not mind if we called their contact to try to get an update of what's going on if we have not heard back. We can infer that they don't want to lose their job by the very fact that they're in the treatment. That would be a good example that applies to us. Minimum necessary. The picture on this slide really talks about you may have a huge chart on somebody, but you only need a little bit. And the spirit of this is you should only be requesting and working with the information that's relevant, even though there's a lot more information out there. Minimum necessary is an official term that is used in the law. So a covered entity must make reasonable efforts to use, disclose, and request only the minimum amount of protected health information needed to accomplish the intended purpose. Reasonable safeguards. Again, this is another term that is officially defined in the law. A covered entity is required to apply reasonable administrative, physical, and technical safeguards to prevent the intentional or unintentional disclosures from happening. So this is the part where we're talking about you can't say we didn't know or we're not at fault. What the law is saying is that you have to make all efforts to prevent anything that's intentional or even unintentional. You have to make reasonable efforts, which is why we're doing this training. This is a reasonable effort to train everybody to understand what you are required to protect. Safeguard considerations. Things to remember with protected health information. Don't have conversations in common areas. Make sure the papers are out of sight for people that are not in contact or related to that person. If files are taken out of the office, you want to put them in envelopes. If you trip and fall and all of your papers fall everywhere, that's something that should have been prevented. You should reasonably anticipate that that could happen, that somebody else would see the information. Disposal of paper information. We want to make sure that we are shredding anything that has PHI with it. Security rule. The security rule establishes national standards to protect individuals' electronic PHI. Sometimes that's referred to as ePHI. As a covered entity, we must ensure the confidentiality, integrity, and availability of all PHI that we create, receive, maintain, or transmit. We have to identify and protect against reasonably anticipated threats to the security or integrity of information. You have to protect against reasonably anticipated impermissible uses or disclosures, and we have to ensure that our staff and our workforce are compliant with this. 3 areas of safeguards. We have to ensure that there are safeguards at the administrative level, at a physical level, and then at the technical level. So let's start with the administrative safeguards. We are required to have a security management process. This is the ongoing risk assessment that we have to do as an organization. We have to have security personnel. Our security officer is our director of IT, James Harbaugh. Information access management. There's a couple ways that this can be achieved. We can limit access through policies, procedures, and technical passwords. So we have to limit who's looking at the information. We have to have workforce training, and we have to have an ongoing evaluation of our processes. Physical safeguards. You're looking at your workstations. Are your screens visible to unauthorized users? Account managers are out in the community. They may stop at a coffee shop and sit down to check their emails. They have to make sure their screens are not visible to other people. In addition, with the mobile technology we have, it should be password protected. Again, you don't want to be searching through your email and somebody can look over your shoulder and see it. Disposal. We have to make sure that we are appropriately disposing of any paper PHI that we have. That's why we have Shred-it as a company. They are a wonderful company that they shred the documents on site. They don't take them to another location and then eventually dispose of it. Media. Are we wiping repurposed computers? We are accountable for making sure that if one of the computers from the clinical staff is reassigned to, say, business, we have to wipe the computer of any technical PHI or clinical information that individual should not be seeing. Accountability. Do we have a record of all of our hardware and electronics? Yes, we're required to do that. We have to track where it is. We have to make sure that it has the appropriate software on it and that we are maintaining the safety of that information. And then our data backup, which we do have. Technical safeguards. Each person should have a unique user identification. Those are your passwords, and we'll get into the quality of passwords in a little bit. Emergency access procedures. If we have an emergency, are we able to access the information, the protected health information? Automatic log off. We should have timeout access, which means you have to re-log in if you've left your workstation for a certain amount of time. And then encryption and decryption. We use Zixmail currently. It's a great software for ensuring that we are transmitting information encrypted. Zixmail. There's a couple technical ways to effectively use Zixmail. The subject line in the email does not encrypt. Therefore, we should never be putting any PHI in the subject line. That means case numbers, initials, and names, if you remember from the identifier screen. In addition, always type the word secure in the subject line to manually make sure the system encrypts an email. Zixmail scans the email for particular words. Most of them are related to healthcare and will miss some of the behavioral health terms that exist. Therefore, if we know that there's PHI in the email, you want to type secure in the subject line, and that will tell the system, encrypt this. If the email stays on the Ulliance server, it's not a problem because everything on the Ulliance server is encrypted. It's when it leaves our company and leaves our server. The caveat to that is sometimes you may think you're just sending an internal email, and what may happen is the third person on the line may be willing to send it or need to send this to a company and not realize that it doesn't have the word secure or it has the person's name in the subject line. It's just good habit and best practice to never use the subject line to put PHI. This is a cartoon to really talk about the important part of passwords, and we're going to get into common things with passwords, mistakes that people make. In 2015, the top 10 passwords that people used are showing up on your screen right now. Most of them are sequential numbers or letters or just common words. Do not use these. It's easy to come up with some unique password that you can remember or a system of how you change it, but try to stay away from these top 10 passwords. Again, we're responsible for making sure that our system doesn't get hacked. And part of that is having accountability for creating a password that's a little difficult for somebody if they're trying to do wrong by the system. Breach notification standard. So let's say that we have been breached and our system has been hacked. A breach is officially an impermissible use or disclosure under the privacy rule that compromises the security or privacy of PHI. Covered entities must provide notifications of the breach involved. The important part for here to know is that as a company, you never want to say that you've been breached. You lose the trust of your clients. You lose trust of the client companies. We want to avoid anything of this ever happening. Breach notification requirements. Following a breach of unsecured protected health information, you may be required to notify the affected individual, the Secretary of the Health and Human Services, and the media in certain circumstances. Breach notification. The company is going to be subject to financial penalties based on the type of breach, and there's 3 levels that go with that. The first level is reasonable diligence. And what these type of breaches are talking about is what are the actions of the company to prevent this from happening is how you're judged with it. So reasonable diligence means the business took care and prudence as expected to prevent a breach. The next level is a reasonable cause, which means that there was an act or omission in which the covered entity or business knew about, and if they had been doing the right thing, probably would have known that act or omission violated, and therefore the breach happened. So it's not necessarily willful, but yet it was still negligent. The next level is willful neglect, which means it was a conscious intentional failure or recklessness or an indifference in the company that the violation occurred. So here are the penalties for the breaches, and really it's important to look at the dollar amount and how it escalates very quickly once it gets to willful neglect. And then they even break it down that if it's corrected within 30 days or not corrected on what the total amount is that the company would have to pay. Review. So let's review a lot of what we learned. For the privacy rule, there's 2 points that you need to know. Do you have a release in place? And if not, is the release of information permitted by an exception? And did you review it with your supervisor? So this is really the takeaway for you, is if you don't have the release and you feel that you can still disclose the information because it's an exception, talk to your supervisor about it. Then the review for the security rule, are you sending protected health information? And if you are, have you implemented all the safeguards that are required to be able to send it? And for the average user at Ulliance, that's going to be your encrypted software. And making sure that you've encrypted the email and you don't have anything left out there hanging that somebody else can look at. A point to remember on this is staff lots of times will get upset that it's becoming difficult for the person on the other end to unencrypt it. What I would like to point out is frequently that's because the people receiving the information aren't aware of the true safeguards for the rule. And if they did know, they would understand why you have to do this and have trust and respect that you are working with integrity and treating everybody's information. That also lets them think if you were providing services to that individual, you would be treating them the same way. It is a struggle to educate everybody why you have to encrypt the information because it does require some extra steps, but it's definitely the right thing to do, and eventually everybody will understand this as time goes on. So always encrypt. Don't get caught up in wanting to give information fast or people that are getting frustrated. As a second note, you can fax the information. Their fax lines are encrypted and aren't going to be breached. So worst case scenario is if you're struggling with the email and encrypting it, you can always just fax the information. So sometimes people are feeling overwhelmed right now that we're just doing too much. We've got the floaty, we've got the arm things on there. Just, are we overkill? Is it doing too much? But we're not. We're really teaching you how to swim. We're teaching you how to be able to do this on your own and not have to give you all the floaties to keep you at the top. And that's the important part of this training.